Welcome, everyone. We'll get started in just a minute. We have a great presentation with Mitch Menzer and EJ Schloss from Cox Castle and Nicholson LLP. And we'll just get started in 1 second. Mitch, we can see your screen.
Okay, good.
Oh, no, but we can see the document, not the PowerPoint.
Oh. Why that is, how's that, better?
Yes. All right, and we will get started. Mitch, do you want to start us off?
Oh, okay. I'm sorry, I can't see anybody, so I'll just jump right in here. Thanks for taking the time to join us for this. Just by way of introduction, EJ and I are attorneys at Cox Castle and Nicholson, which is a real estate focused law firm. We have offices in San Francisco, Los Angeles, and Orange County. EJ and I are part of the land use team, which is about 35 lawyers handling land use entitlements and land use litigation for a wide variety of projects. A large focus on housing, both market rate and affordable. We also have a team that specializes in representing developers of affordable housing, both for-profit and nonprofit, in all aspects of that. And we're really happy to be back with SCAMP. EJ and I were part of a presentation at the SCAMP conference last year on new land use tools for development of affordable housing. And it's great to be a part of this. I don't know of another real estate organization whose members are as engaged in policy and legislation as SCAMP. So we're very happy to be a part of it. This is the outline of the bills that we're going to be reviewing today. As it has been for the past 5 or 6 years, the legislature has been very productive when it comes to housing legislation, particularly affordable housing. This last year, there were 56 different housing-related bills passed. Our firm issued a client alert, which summarizes about 30 of those bills, and we'll make that available. We'll add the link to the chat, perhaps, or it's at the end of the slide presentation, and we'll be able to make these slides available. But we've selected about a dozen bills here that we think are most important and perhaps most valuable to the affordable housing developers. The bills are wide ranging. They're all different topics. Some of the bills are brand new with new CEQA exemption, a new streamlined process, and we'll cover those. And then there are a lot of bills that are refining some of the existing legislation. So let me start out with SB 423, which are important amendments to SB 35. You may have followed this, but it had a lot of ups and downs during the legislative year. It was introduced, it was pronounced dead, it came back to life, and it was passed, and it makes some very important changes. I'm going to just, in case you're not familiar with SB 35, I'm going to do a quick review here for you. SB 35 provides a streamlined ministerial approval process for certain qualifying projects, and it's therefore exempt from CEQA, which is very important. The requirements are generally there's a affordable housing set aside that's required. Obviously, for 100% affordable projects, that's easily met. SB 35, before being amended, required both prevailing wages and a skilled and trained workforce, which meant that virtually all of the construction workers had to be union members, and the general contractor and subcontractors all had to be union shops, which can cause an increase in the construction costs. Secondly, importantly, the SB 35 is scheduled to sunset January 1st, 2026. SB 35 was not available in the coastal zone, and SB 35 has some requirements basically to meet urbanized and infill requirements. And then in addition, there are about a dozen other site requirements that are part of SB 35 to avoid sensitive landscapes and the like. And some of these concepts you'll see are imported and used in other bills. So that's a quick summary. Let me explain what SB 423 actually does, which is, first of all, it extends the sunset date to January 1st, 2036, which is very important. SB 35 was proven to be one of the most productive of the housing legislation, along with, say, the density bonus law and the Housing Accountability Act. The Turner Center at UC Berkeley estimated that in its first 4 years, SB 35 was responsible for over 18,000 units, affordable units. And this is obviously very important to be able to keep this going for another 10 years. Another set of important requirements have to do with the construction labor requirements. So first off, SB 35 for 100% affordable projects eliminates the skilled and trained workforce requirement. And it does this in two ways. First of all, for all projects under 85 feet, the skilled and trained workforce requirement no longer applies. That's both market rate and affordable. If it's 100% affordable and it's greater than 85 feet, then there's also an exemption from the skilled and trained workforce. So that's obviously a big plus. In addition, SB 35 imported some new labor requirements that were used in AB 2011. So going forward, there's a requirement for projects over 50 units to seek out apprentices for the construction. There are requirements to pay monthly health care insurance for the construction workers. And then there are some new record keeping and reporting requirements. But on balance, this is obviously beneficial. Moving to the coastal zone, as I mentioned previously, SB 35 was not available in the coastal zone. And now, if the project meets certain requirements, it will be able to be used in the coastal zone. So the requirements are, most importantly, the city has to have an approved local coastal plan and land use plan. The site can't be on certain sensitive lands, such as within 100 feet of wetlands, or within the first 300 feet from the beach, or on submerged lands and the like. So those are due diligence issues. There's a very important addition through SB 423 for coastal zone projects. The density bonus is not available in the coastal zone, and SB 423 makes density bonus, both the bonus as well as concessions, incentive, and waivers available in the coastal zone for SB 35 projects. So this is kind of a foot in the door where perhaps going forward, the legislature will expand the density bonus to be applicable in the coastal zone, even outside of SB 35 project. In terms of the affordability requirements, under SB 35, certain cities that haven't met their above moderate income RHNA numbers are subject to a 10% affordability requirement. Obviously, 100% affordable project will meet that, but in those jurisdictions, the affordability has been deepened in the sense that going forward, instead of being able to rent to households that are at or below 80% AMI, these will now have to be at or below 50% AMI. And that's perhaps going to affect some financing as well. A benefit of SB 423 is that it specifies that for 100% affordable projects using SB 35, you can now use maximum rent levels that are available through the financing mechanism. So that may make TCAC rent levels available rather than the HUD or the Health and Safety Act rent levels. So that's an important positive development. And finally, there are a few other odds and ends that came into SB 423. Some cities had used a city council or planning commission requirement to make the determination that the project is consistent with all the objective standards. SB 423 pushes that down and requires that it be the planning director or equivalent to make that determination. So that's an administrative determination now. And then it also put limits on additional studies that a city can require as part of an SB 35 project. Those are now limited to studies that relate to consistency with the objective standards or the ability to satisfy a building permit or another post-entitlement permit. And then finally, SB 423 adds a new public hearing requirement for projects that are located in a low or moderate resource area as designated by HCD or TCAC. And that has to occur before the application is filed. It shouldn't interfere with the ministerial streamlined nature of the project, but there is more community input required in these areas. So that's SB 423. I'm going to hand it over to EJ now to discuss a new bill, SB 4.
Sure, and thanks, Mitch. Yeah, this is EJ Schloss. I'm a land use attorney with Cox Castle, as Mitch mentioned. I'm based out of the LA offices, and yeah, I do a lot of work primarily in Southern California, but a little bit of work in Northern California as well. So I'm going to get us started with SB 4. So taking a step back, the state legislature has in the past several years sought to facilitate the development of housing on underutilized sites, specifically sites that may not currently permit residential uses. So we saw this last year with AB 2011 and SB 6. And now this year we have SB 4, which targets properties owned by religious institutions and private higher education institutions. So SB 4 is the Affordable Housing on Faith in Higher Education Lands Act of 2023. The primary benefit it provides is that is a new streamlined ministerial approval process for eligible 100% affordable housing development projects, which are deemed a, quote, use by right. Next slide, Mitch. So who can use SB 4? First of all, the property must be owned by a religious institution or an independent institution of higher education. Public higher educational institutions are excluded, so the higher educational institution must be non-public. This means you can't do an SB 4 project on a property owned by the University of California, but you could maybe do one on a property owned by Loyola Marymount University. The applicant must be a qualified developer, which includes local public agencies, a nonprofit entity, a developer that contracts with a nonprofit entity that has a state exemption under the state tax code, and a developer that the religious institution or independent institution of higher education is contracted with before to construct housing or other improvements to real property. Next slide, Mitch. So the housing development project must meet, there's a lot of site and project eligibility criteria that are associated with SB4. I'm going to kind of run through a lot of the big points here. And we're going to circulate these slides later so you can reference everything again. But just keep in mind that there's a lot of site and project eligibility criteria that you'll want to check for each of your projects to make sure it can conform with your envelope and with your design restrictions. So the first is the housing development must provide 100% of the units, exclusive of the manager's units, must be affordable to lower income households, except that up to 20% of the units can be moderate income and 5% of the units can be for staff of the institution owning the land. In addition to residential uses, SB4 permits some ancillary non-residential uses. So in a single family residential zone, childcare centers and facilities operated by community-based organizations may be permitted. And in all other zones, i.e. non-residential zone, non-single family residential zones, the development may include commercial uses that are permitted without a conditional use permit or planned unit development permit. So there's a potential here for a sort of mixed project. Next slide, Mitch. So what are the development standards that apply to an SB4 project? So there's a bifurcation here. If the project is in a zone that allows residential uses versus if the project is in a zone that does not allow residential uses. If the project is in a zone that allows residential uses, the allowed density is the density appropriate to accommodate housing for lower income households under housing element law. And the height limit is 1 story above the maximum height otherwise applicable to the parcel. So you might be asking, what is the density for lower income households under housing element law? This is referred to in housing element law as the Mullen densities. So for a urban, for a metropolitan jurisdiction within an incorporated county, which is probably the vast majority of the work that we do, it's going to be 30 dwelling units per acre. If the local, so with respect to that, if the local government allows for greater residentiality on the project site, then that density will apply. And that also applies if the local government allows for greater residential density on an adjoining parcel. Keep in mind that the density bonus will also apply. So if you need to get out of that height restriction, you can use a density bonus concession, incentive, or waiver. If the project is in a zone that does not allow residential uses, the project is allowed a density of 40 units per acre and a height of 1 story above the maximum height otherwise applicable to the parcel. Except that if local standards allow for greater residential density or heights on the project site or adjacent parcels, then that greater standard will apply. You can also use density bonus concessions, incentives, or waivers on for a project in a zone that does not allow residential uses, but you cannot use it to exceed the maximum height permitted. Next slide, Mitch. All right, even more eligibility requirements. So the first is with respect to parking. Generally, the project must provide off-street parking of up to 1 space per unit. In certain cases, there might be no parking restrictions whatsoever. So if the project site is within 1/2 mile of public transit, or if there's a car share vehicle area within 1 block of the site, then you are not subject to parking requirements. Safety features. You can see here that there's an installation requirement for MERV 13 filters if the housing is within 500 feet of a freeway. You're still subject to tribal consultation requirements. And keep in mind that if the project would adversely affect tribal cultural resources and the effect cannot be mitigated, then the project cannot use SB4. Other development standards, the project must otherwise comply with the local jurisdiction's objective standards that are not in conflict with what's in SB4. And another benefit here is if the project is consistent with all objective subdivision standards, an application for a subdivision map is exempt from the California Environmental Quality Act. This doesn't mean that your subdivision map is ministerial. It would still be a discretionary approval. It just means that you wouldn't be subject to CEQA for the project altogether, including the subdivision map. Mitch, next slide. More eligibility requirements. SB4 requires compliance with prevailing wage requirements. And for certain projects over 50 units, it incorporates prevailing wage and other labor standards that are currently in AB 2011. Replacement unit requirements. If the project would demolish existing residential uses or is located on a site where residential units have been demolished in the past 5 years, the project must meet SB 330's replacement unit requirements. Next slide. All right, site eligibility requirements. So there are a ton of site eligibility requirements. We've sort of seen this in the past few years with AB 2011 and SB 35 specifically comes to mind. So the site must be a legal parcel. It must be owned by the institution on or before January 1st, 2024. Needs to be in an urbanized area or urbanized cluster within the bounds of an urbanized area or urbanized cluster in an unincorporated area. It needs to adjoin parcels with urban uses on at least 75% of the perimeter, so it can't be in too rural of an area. And next slide. The site cannot be any of the following. There's a big list here. I'm not going to get too far into them just because there's so many little items here, but just keep in mind that a lot of the ineligibility criteria of SB 35 will apply. And there are other public policy considerations that go into these site eligibility requirements. So you can see in this list that there's a desire to not locate SB4 projects in close proximity to industrial uses and facilities that extract oil or gas. Next slide. SB4 and existing uses. So if there's a religious institutional use or a use that was previously existing and legally permitted by the city or county on the site, that can remain or be accommodated in the project, provided the following criteria are met. So essentially these 3 criteria operate to limit the amount of square footage that the non-residential space can carry over into the new project. And the 3 criteria are there. So you can't exceed the square footage that was previously permitted. You can't increase parking requirements, and you need to comply with any prior conditions of a conditional use permit. Next slide, Mitch.
Sorry, it's not advancing. Oh, there we go.
Like I mentioned earlier, SB4 is subject to a streamlined review and ministerial approval process. We've got the details here, but essentially mirrors what we've seen in the past with AB 2011. So a local agency must do an initial review on the project to determine its compliance with objective planning standards within either 60 or 90 days, depending on the number of units in the project. And a local agency may conduct design review of an SB4 project, but it has to do so within either 90 or 180 days. And another thing to note here is SB4 imports certain requirements from SB 35 that deal with the life of the approvals, project modifications, if subsequent permits are needed, or if there are subsequent modifications, and necessary public improvements. And that's it for SB4, but we're going to move on to the next slide for AB 1287. So again, like we've seen in past years, the state legislature has strengthened density bonus law in order to increase the amount of affordable and non-affordable housing development subject to the density bonus law. With respect to 100% affordable housing projects, we've kind of identified the primary benefit of AB 1287 is that it increases the number of concessions and incentives. that a 100% affordable housing project is eligible for from 4 to 5. AB 1287 also does something else. It provides an additional 50% bonus in density, up to 100% for projects that are already eligible for a 50% density bonus, in exchange for providing additional VLI or moderate income units. However, AB 1287 provides that the additional 50% density bonus does not apply to housing developments that would restrict more than 50% of the total units to moderate income, lower income, or very low income households. So this would seem to preclude the use of AB 1287 in the case of 100% affordable housing projects. Mitch, next slide. But keep in mind that under existing density bonus law, a 100% affordable housing project would still be entitled to a density bonus as follows. So you can get 80% of the number of units for lower income households, or there's there's no maximum control on density if the project is within 1/2 mile of a major transit stop, or if the project is within a very low vehicle travel area. And that's it for AB 1287.
Okay, thank you, EJ. We're going to move to the CEQA section of the presentation. We have 4 CEQA-related bills. The first is AB 1633, which I think is one of the most interesting bills in a long time, in the sense that it addresses a problem that maybe some of you have experienced, which is you have a project and you think the project qualifies for an exemption under CEQA, perhaps the Class 32 infill exemption, and yet the city or jurisdiction takes a more conservative view and says, no, we don't think it's proper for an exemption. We want to use an MND or even an EIR. And obviously an exemption is about as good as it gets under CEQA because it's not subject to a public review and comment. And in terms of defending the CEQA document in court, an exemption is probably the strongest position to be in. But if the city is not willing to use an exemption, and there's nothing under CEQA that says you can challenge that, there's a kind of an awkward position at the beginning of a project when you're submitting a project to suddenly be confronting or in an adversarial position with the city. So this slide shows the many exemptions that are available, including AB 1449, which is a new one that EJ will discuss in a moment. So AB 1633 addresses this problem, and it does it in an interesting way by putting it in the Housing Accountability Act and making the local agencies' failure to use an exemption when it's warranted a violation of the Housing Accountability Act. And with that come some very strong remedies, meaning a court's obligated to order the city to comply with the Housing Accountability Act and use the exemption. Attorney's fees are available and fines may be available in certain circumstances. So for an exemption, the applicant only has to show that it has substantial evidence that it meets the requirements of the exemption. And if it's a categorical exemption, you'd need to have substantial evidence that none of the exceptions apply. So it's essentially as if you were preparing the document for a category, your consultant was preparing a document for a categorical, for an exemption. You'd want to have evidence supporting all of the different requirements. And from there, the developer is required to give written notice to the local agency that it intends to use the exemption and contest the exemption. And then the local agency has 90 days to review this, study this, and hopefully come to the right conclusion. This AB 1633 only applies in an infill setting. And again, there's a long list of urban infill requirements that you'd need to meet, including 10 of the criteria imported from SB 35 and There's also a requirement that it be in an urbanized area, and there's a new definition of what that means by relation to a high quality transit corridor or a major transit stop, a very low vehicle travel area. And it also includes a set of requirements that are also used in AB 1449, which have to do with proximity to what they call amenities, but they're essentially community features like a supermarket, pharmacy, drugstore, medical clinic, and the like. So hopefully most projects will be able to meet these requirements. You may be wondering about what about an MND or an EIR if the city is taking the opposite position from what the developer wants to do. It's a very different setting for an MND or an EIR. In those instances, it would only apply if the city, for example, had a complete EIR at a public hearing, and instead of adopting that EIR, if all the requirements were there, it instead, to delay acting on the matter, required further study when that wasn't justified. So hopefully this won't be, this was an instance from a project in San Francisco that actually gave rise to AB 1633. Hopefully this won't be a situation you're in. And I think it's best to focus on the ability to use it for being able to use an exemption. The next bill I want to talk about is SB 69, which adds a new filing requirement for a notice of determination or a notice of exemption. So in order to trigger the short statute of limitations period, under current law, the city needs to file that notice of determination or notice of exemption with the county recorder. And SB 69 adds another requirement. So now the city needs to file that with the state clearinghouse in the Office of Planning and Research. And if it fails to do that, if it fails to get those filed in both locations, then the statute of limitations period will not begin to run, and it would potentially be subject to a 180-day statute of limitations. The bill does require both the county and the state clearinghouse to set up a website where they will post the NOE or the NOD within 24 hours of receipt. And that'll be convenient to just be able to verify that that those filings have been made. So something new to worry about in terms of getting the NOD or the NOE filed. The next bill is SB 1307. This came out of the infamous case involving student housing in Berkeley, where the Court of Appeals made the determination that the EIR was inadequate because it didn't study the noise that might be generated by the students and their guests. That actually went up to the Supreme Court. The legislature jumped in last fall and passed SB 1307, which was signed and went into effect. And the practical result of this is that your MND or your EIR does not need to study or include an analysis of noise impacts from residents or their guests. And now I'm going to hand it over to EJ to talk about a new CEQA exemption.
Sure, yeah. And I'm going to talk about AB 1449, which provides a new CEQA exemption for 100% affordable housing projects that meet all of the site and project eligibility criteria. Next slide, Mitch. So AB 1449, what does it do? It provides that a broad variety of actions related to eligible 100% affordable housing projects are exempt from CEQA. I've highlighted two here, so the issuance of an entitlement will be exempt from CEQA, and then any legislative action such as a rezoning, specific plan amendment, or general plan amendment required for the affordable housing project will also be exempt. You'll see in this list that there are other related actions that might be exempt. So just keep in mind that this is a broad exemption and it's meant to apply to a lot of different actions involving 100% affordable housing projects. Next slide. So what are the required eligibility criteria? First, it must be an affordable housing project, meaning a project consisting either entirely of residential uses or with at least 2/3 of the square footage designated for residential use. All residential units, excluding any manager's units, must be dedicated to lower income households. And the project must meet the labor standards that are set forth in AB 2011, i.e. prevailing wage requirements. And if the project is greater than 50 units, the project must meet additional apprentice and healthcare expenditure requirements. Next slide, Mitch. So in terms of site eligibility criteria, there's only a few for AB 1449. It must be in a city where the city boundaries include some portion of an urbanized area or urban cluster, or if it's in an unincorporated area, the site is wholly within an urbanized area or urban cluster. It could also be within a half mile of a high quality transit corridor, a major transit stop. It could be in a very low vehicle travel area, or it could be proximal to 6 or more enumerated amenities. So the statute lists all these various types of amenities. And so as long as the project is proximal to one of those amenities or to 6 or more of them, then the site is eligible. And again, here we see that there's a 75% perimeter requirement. At least 75% of the perimeter of the site must adjoin urban uses, or at least 3 sides of a 4-sided project site. So again, this eligibility requirement is designed to exclude properties in rural areas or that are not located close to development. Next slide. Additional eligibility criteria: the project must be subject to a recorded California Tax Credit Allocation Committee regulatory agreement. The project must be able to be adequately served by existing utilities or extensions. A public agency has confirmed that the SB 35 eligibility criteria have been met. The project proponent has completed a phase 1, and if a wreck is found, the proponent has undertaken a preliminary danger assessment and mitigated any hazardous substances or significant hazards to a level of insignificance. And there's specific eligibility requirements for project sites where multifamily housing is not currently permitted use. So all of the following must be met. None of the housing can be within 500 feet of a freeway. None of the housing can be within 3,200 feet of an oil or natural gas extraction or refinery area. And the site cannot be within a very high fire hazard severity zone. So that's it for AB 1449. We're going to move on now to AB 894, which involves shared parking agreements for underutilized parking. So AB 894 requires local agencies to allow entities with underutilized parking to share their underutilized parking spaces with the public, local agencies, or other entities, if those entities should submit a shared parking agreement to the local agency and information identifying the benefits of the proposed shared parking agreement. So taking a step back, a lot of projects cannot, for a variety of reasons, meet their parking requirements. Oftentimes, it's a discretionary approval to go to a local agency and ask for a parking variance or the submission of a parking agreement. And so this essentially requires, in certain cases, local agencies to approve certain eligible shared parking agreements. Next slide, Mitch. So a local agency must approve a shared parking agreement if it includes a parking analysis using peer-reviewed methodologies developed by a professional planning association that is sufficient to determine how many parking spaces can be reasonably shared between uses to fulfill parking requirements, and if it secures long-term provision of parking spaces or affords the opportunity for periodic review and approval by the local agency. A local agency must also allow parking spaces identified in the shared parking agreement to count towards meeting any automobile parking requirements for new or existing development or use where the following criteria are met, or where any of the following criteria are met. The entities that will share the parking are located on the same or contiguous parcels. The sites of the entities that will share parking are within 2,000 feet of travel by walking, or the sites of the entities that will share the parking are separated by more than 2,000 feet, but there is a plan for shuttles or other accommodations between those two sites. Next slide, Mitch. So there's also provisions in here that deal with if a shared parking agreement is submitted without the required parking analysis. In that case, the local agency still maintains the discretion to decide whether to approve or deny the shared parking agreement and to determine the number of parking spaces that can be reasonably shared between the two uses. Shared parking agreements for developments of 10 or more residential units or 18,000 square feet or more are still subject to are subject to public noticing and potentially public meeting requirements. AB 894 cannot be used to reduce requirements for parking spaces accessible to persons with disabilities, or to reduce the percentage of parking spaces designated for electric vehicles. And AB 894 also requires local agencies and project proponents to examine the feasibility of shared parking agreements to replace new parking construction or limit the number of new parking spaces for projects funded by state funds, and where public funds are being used to develop a parking structure or surface parking, and the public funding is awarded after June 30th, 2024. So just keep this in mind. This provision might come into play on some of your projects in the future. And that's it for AB 894, Mitch.
Okay, I'm going to explain the amendments to the Surplus Land Act, which is obviously very important to the affordable housing industry. The affordable housing industry, in effect, gained a right of first negotiation when a local agency, cities, but also districts and other entities have surplus land and intend to sell it. So it requires, through housing and community development oversight, that those local agencies provide a notice of availability to all the affordable housing developers who've registered with HCD. It requires them to make it available, to solicit offers, and to negotiate in good faith before it can put the surplus land on the market for something other than affordable housing. That applies in all instances except with respect to exempt land, and exempt land is defined in about a dozen specific definitions. And obviously that, there's a great deal of interest in making sure that those exemptions are not expanded to the point where this right of first negotiation is going to be lost or minimized. The amendments to the Surplus Land Act through SB 747 and AB 480 were quite numerous and complex, and in many cases very technical. I'm not going to go into all of these, but there were some fine tuning of some of the exemptions. For example, the lease term, if the entity was leasing property, there was a new exemption created for a public use transport airport where residential uses are prohibited, and there were clarifications to what participating in negotiations meant, so that cities had a little more flexibility or leeway to take steps before having to issue a notice of availability. The major amendments to the Surplus Land Act are in this category, where it first of all created a new exemption for the sale of land for 100% affordable projects. And in this instance, it no longer requires open competitive bids. So a local agency could enter into direct negotiations with an affordable housing developer to build an affordable housing project on that surplus land. It requires that, or it permits up to 25% of the units to be at moderate incomes, as long as the rest are lower income. And it also has an unusual rent provision, which says that the maximum rent can be up to 80% of the median market rents for the neighborhood. And in this exemption, notice to HCD is still required, although the local agency doesn't need to issue the notice of availability. The other major changes were taking the existing exemption for projects with at least 300 units, of which 25% would be affordable, and that would comply with the notice of availability requirements. And it basically divided that up into two categories, one for sites that are less than 10 acres, and the other for sites that are greater than 10 acres. Less than 10 acres essentially remains the same. There's the notice of availability and a competitive bid requirement. For properties that are 10 acres or more, there's now a kind of minimum density that's based on a formula. And if there's a mixed use project, then there's a phasing requirement where the delivery of the affordable units basically has to keep pace with the delivery of the non-residential development. And then finally, these bills created a new category for exempt land where, again, there's no competitive bid process, but these developments have to be located outside of an urbanized area. I don't know how applicable that will be, but again, it's for a mixed use development. At least 25% of the residential units have to be for low income, and at least 50% of the overall project has to be for residential use. So, these are opportunities where one would hope affordable housing developers will have an opportunity through these exemptions to perhaps team up with a market rate developer that doesn't have the expertise in affordable housing or affordable housing finance. And hopefully by having to comply with the notice of availability requirements, that'll create these type of opportunities. Next bill, just very quickly, AB 1485 makes it much easier for the Attorney General to intervene in any litigation that involves Housing Element Law, Housing Accountability Act, Density Bonus, Housing Crisis Act, a long list of housing bills. And it gives the State Department of Housing and Community Development the same right to intervene, which presently it doesn't have. So we've all seen that HCD has become much more prominent and much more effective in protecting the rights of housing developers and weighing in with cities with technical guidance and the like. But now it'll have the ability to intervene in litigation that's affecting those projects. And we have a couple more bills that EJ will tackle.
Sure. Yeah, there's a couple more miscellaneous bills here. The first is AB 1114, which deals with post-entitlement phase permits. So the concern of the legislature a few years ago was that certain municipalities were granting discretionary entitlement approvals, but might have been dragging their heels on throughout the permitting process thereafter. So AB 1114 is it amends the current government code section 65913.3, which deals with post-entitlement phase permits. AB 1114 amends the current provisions by specifying that it applies to, quote, all building permits and other permits related to housing that are issued under a state or local building code, whether discretionary or non-discretionary. And then next slide, Mitch. And there's also AB 1490, which deals with adaptive reuse projects for 100% affordable housing. AB 1490 provides that regardless of any general plan or zoning prohibitions, local jurisdictions must allow as a use adaptive reuse projects that provide 100% affordable units to low-income and very low-income households that involve the retrofitting or repurposing of an existing residential or commercial building, meet certain siting requirements that are in the bill, and are located within 1/2 mile of a transit stop, or where at least 75% of the perimeter of the site adjoins parcels that are developed with urban uses. And so just to be clear, this doesn't mean that the project is subject to a ministerial review process. It just means that the use is permitted by right. So keep in mind that objective design guidelines will apply except for maximum density requirements, maximum FAR requirements, requirements to add additional parking, and requirements to add additional open space, which can be difficult in these conversion projects. The project will be subject to a streamlined approval process, but again, it's not necessarily a ministerial approval process. And an eligible project will also qualify for the benefits of the HAA. And I think that's it, Mitch. We have one last slide.
Okay, yes, here's the, at the bottom is the link to our client alert, which summarizes these laws and about another 15. And our contact information is here. We'd be, happy to hear from you if you have questions that we can't address here, or if you're seeing situations that might or might not apply to these new bills. We're interested to see how they work in the real world. So I'll leave it at that. Danielle, are we going to try to take some questions, or how should
Yes, so we
we?
have about 10 minutes for Q&A, and we've got a few questions in the Q&A box and then some in the chat. I'll start with the Q&A box. A majority of these questions seem to be about SB4, but I'll make sure I let you know what bill they're referencing before I ask the question. So this first one says, for SB4, must the religious or educational institution have owned the property for a certain period of time before pursuing entitlements under SB4?
Yeah, that's a great question. And I like the second part of this question that you didn't read, which is it possible to launder a non-religious educational development site through SB4? So I like the thinking here. What SB4 says is that the development must be located on land owned on or before January 1st, 2024 by an independent institution of higher education or a religious institution, meaning that you can't launder it in the future. That property needs to have been owned on or before January 1st by the institution.
Thank you. The next question is also about SB4. Is there an active effort to educate religious institutions about SB4 and encourage them to develop their properties?
That's a great question. And I haven't heard of any active statewide effort on that, but I think that might be something an affordable housing developer might go out and do. But I'm not aware of any specific entity or group that's doing that statewide.
This would be a great project for SCAMF in terms of helping to educate the many religious institutions in the area, many of whom have surplus land, many of whom, would be eager to help provide solutions for the housing crisis and homelessness crisis. And I think it's a great opportunity for make the connection between developers and the institutions that can use SB4.
Yes, I agree. That'd be a great opportunity for SCAMP. We'll definitely brainstorm that. All right, so the next question is, in theory, could a private property owner provide an eligible nearby school or faith-based institution access to their land via long-term lease, for instance, in return for SB4 streamlining? Second part is, with the school district or FBO in return contracting with the private property owner to provide, design, build, operate, maintain the 100% affordable housing?
Yeah, good question. I think it's similar to the first questions. Unfortunately, the development has to be located on land that's owned on or before January 1st, 2024 by the institution. So you couldn't do this going forward. But that's a good question.
Okay, the next question, I know this was also in response to SB4, even though it doesn't say this. For zones that allow residential uses, does a residential use need to be a primary use in that zone?
I don't know the answer to that question. I don't know if it's specified in the bill. I think it just states the residential uses are allowed, but I can look into that.
Okay, next question. Regarding SB 423 for coastal zones, is the density bonus allowed?
Yes, so you can use the density bonus as part of that SB 35 project in the coastal zone, according to SB 423.
Okay, next question. Is that code section 65913.4 applicable for most of these housing bills?
65913.4 is SB 35. And some of those provisions are incorporated. For example, that list of about a dozen site characteristics that would preclude a project, that's been imported into other of these streamlining bills like SB or AB 2011 and SB 6 and some of the others, just because it's, it's a handy way of addressing those same concerns of putting housing in those areas. So, you see across these bills, the legislature is grabbing from SB 35 and from other bills, AB 2011, for example, with respect to construction labor requirements, because they had something that was passed before, and it makes it easy. So I think that's probably what you're referring to in that code section.
Okay, great. The next one is with SB 4, how much interest is a religious institution required to own? Is 51% enough?
SB 4 doesn't specify. It only states that the development is located on land owned by the institution. So there's no percentage requirement. I think that's an open question.
Okay, great. And actually, I'm going to go to the chat really quick. There are two questions that are kind of similar, so I'm going to combine them also for SB 4. The first one is if a nonprofit controlled or managed by a religious institution would qualify as a religious institution for SB 4. And the second part of that question, which is combining it, is if SB 4 applies if a nonprofit purchased a church before 2024 that was vacant but used to have a congregation. So one is if a nonprofit is managed by a church or a religious institution, the other is if a nonprofit purchased a religious institution before 2024.
I think that I'll answer the second one first. I think that would be fine, but we'd want to look into it more. Again, in that case, the development would have been on land that is owned by the institution before January 1st, 2024. So in that case, it could work. But can you remind me what the first question is again?
Yes, it was if a religious institution owned a nonprofit, would that nonprofit qualify as a religious institution in regards to SB 4?
There are qualified developer requirements. And I'd have to check if that entity structure would work, but that might work. Let me look into that a little bit more.
Sounds good. We have this question about SB 35/423. It says the legislation does not address housing projects proposed to be within 70 dBA CNEL of an airport influence area. It's not listed as part of environmentally sensitive criteria. This attendee recently got an application for proposed housing underneath the flight path to LAX. And their airport plan discourages this development. But since it was ministerial, they're not able to submit it for an ALUC review. So I think they just want your thoughts. And again, this is in regards to SB 35/423.
Yeah, I'm a little unclear about what the application is for and to whom it's for. I would imagine if it's in the city of LA, or even if it's not in the city of LA, SB 35 should apply to make that a streamlined ministerial approval. The ALUC approval is a different and separate approval, which even if it's something that's not subject to SB 35, I don't think it should, eliminate the streamlined ministerial nature of the main entitlement, the entitlements with the city of LA or the other jurisdiction. So I'm just a little unclear why that would affect SB 35 if that's what the attendee is saying.
All right, thanks.
I'd be happy to talk offline about this as well.
Great. And yes, again, Mitch and EJ's information is right there. We're going to have one last question, even though I know there's some left just because we're hitting our time. But again, thank you, Mitch and EJ, for all of your time today. And thank you for providing your contact information. Our last question is about SB 894. Is a public hearing a requirement for shared parking for 10+ unit housing? And they're asking, doesn't that make it discretionary, or does it only give them authority to require a PH?
So just to be clear, and it might not be clear from the slides, but that public hearing requirement only applies in limited cases, and that's where a shared parking agreement is submitted without the parking analysis. So in that case, a local agency is required to notify all property owners within 300 feet of the project, and let those property owners know that they have 14 days to request a public meeting, and that they can request, the property owners can request a public meeting, in which case the local agency shall hold a public meeting on the shared parking agreement and approve or deny the project. So again, keep in mind, if the analysis is not included with the shared parking agreement, then the local agency still retains some discretion to approve or deny.
Great, thank you guys. Just a reminder to all attendees, I will be sending out the slides and recording of the session later this afternoon. Thank you all for attending.